Hi, thanks for using my court coach. I'm Sarah and I'll be your instructor today as we talk about the order after hearing on a motion to cancel or set aside a voluntary declaration of parentage or paternity, also known as the form FL290. As with all our court forms, you want to fill in your identifying case caption information at the top. Below that, you're going to list the date of the hearing, which department it took place in, and the name of the judicial officer who heard the matter. Below that, you're going to identify each of the parties that were present at the hearing, and if there were attorneys present for any of the parties, then you want to mark the box that says attorney present and also list their names. In line number 3, you're going to mark and state the date that the paternity voluntary declaration of parentage was filed on and the name of the child that it was for. And then you want to list what orders the court made. Either the court agreed to cancel or set aside the voluntary declaration of parentage or paternity or not, or maybe they made an order that it is void or it is not void. If they did order that it is void, state the following grounds that the court cited for that finding. If the court orders the parties to complete genetic testing, mark box number 4, and if there was a date by which that testing is to be completed by, then list that date here. Genetic testing should be coordinated with the local child support agency. And then whatever orders the court made regarding how that genetic testing is to take place, below in 5, you're going to specify. So either one or both of the parties and the minor child are each to submit to genetic testing as directed by the local child support agency, or the parties, maybe there was an order for them to advance the cost of the genetic testing or reimburse the local child support agency for genetic testing costs. And if there's an amount already known, then list that here. If there is a further hearing date set to go over the results of the genetic testing, then mark item 6 and list the date for that hearing date. If the court orders that the current support custody visitation orders are to remain in effect pending further court order, mark box 7A. If the court modifies those orders in any way, mark 7B and specify how those orders have been modified. If you need to attach an additional page to this because this is not enough space, go ahead and do so. And then if the court does find that the voluntary declaration of parentage or paternity is canceled or that it is void, then this just instructs that the court clerk is to send a copy of this order to Department of Child Support Services. Leave the signature line for the judicial officer blank. This does need to be submitted to the other side for their approval, so make sure to write in their name, and then this is where they would sign, mark the box that identifies their role to the case. Once this has been signed by them, you can submit this for processing with the court, and once the judge signs and stamps it, it becomes an official court order. I hope you found this helpful. Good luck.